Hello Shah.
Hello Zambi.
So I heard you want to talk about something.
Yeah. So, hey guys. Lately I've been reading about something where it says like in trade activities, it is not only about profits, losses, and business strategies that must be faced by business actors, but also about legal aspects when a dispute occurs. If a trade dispute occurs, there are two ways to resolve this issue: litigation and non-litigation. So litigation is a process of resolving disputes in court, while non-litigation is resolving disputes outside of the court. Traders tend to choose non-litigation dispute settlement paths because of quick and efficient settlement process. In most situations, arbitration is a choice of business actors to solve problems without going through a judicial institution because of its efficiency, accessibility, and protection of the rights of the parties. In that case, I felt that using the form of arbitration for business-related issue is way more better than using conventional litigation approach in the court of law.
Yeah, I agree with you,
Yeah,
Shah.
I agree with you.
So what do you guys say? You guys agree with the article?
How is it possible, Shah? And I'm totally disagreeing with you.
Well, honestly,
Yeah,
we also
also-
disagree with you.
But why? Okay, why not? Let's define the arbitration and litigation. We can decide whether it is better for the business-related issue towards the end of this discussion.
Yeah, sounds to be good. Shah.
Okay,
Sounds like a great
we
plan.
agree with this.
Yeah.
Guess what is arbitration? Is processing in an argument is submitted by the agreement of parties where two or more judges make a deciding on the argument. Arbitration is a private process between two parties and it's only limited evidentiary process, and for the jurisdiction depend on type of the case. The party able to be selected to judge mostly based on the binding, not necessary to appeal. The time to process is the selection by the judge mostly during a short time, and the fee needs for the advocate and use of judge limited time at the discretion of the parties.
And most importantly, you know why we say arbitration is way more better than litigation, especially on the business-related issue. Well, there are 7 types of advantage. First would be fairness, timeliness, cost, confidentiality, finality, agreeableness, and simplified procedure. So I will explain one by one. So for fairness, both parties agree to the arbitrator, resulting in a fair outcome, especially when compared to a traditional legal trial in which neither party has control over the jury or judge selection. Parties can also agree to choose an arbitrator that has an experience in the specific area of legal dispute. For timeliness, a legal resolution through arbitration is much quicker than waiting for a trial date. Arbitration is less formal and more flexible in terms of schedule. For cost, arbitration does not include expert witnesses or require as much legal preparation. Both parties often split the cost of the arbitrator, meaning the process is much cheaper. For confidentiality, the arbitration legal process is more private than a trial. And finality, there is a level of finality to the arbitration process because it cannot be appealed. Both parties can move on following the outcome. Agreeableness, arbitration often results in an agreeable outcome as parties are encouraged to come up with a solution together. And last one would be simplified procedures. Legal outcomes are more adaptable to the two parties present in the dispute. Each party does not have to hire an attorney for representation.
Well, that is advantageous. There must be pros and cons for arbitration. So what are you guys going to say for these advantages?
So well said, but at the same time there are some advantages as well, where if arbitration is binding, both sides have to give their right to an appeal. That means there is no real opportunity to correct what one party may feel is an erroneous arbitration decision. If the matter is complicated but the amount of money is involved is modest, then the arbitrator's fee may make arbitration uneconomical, and it may be cheaper and try the case before a judge in general district court, where medical evidence can be presented by affidavits instead of paying the doctor to testify. But however, the amount can be awarded in this court currently is limited to $50,000 only. So rules of evidence may prevent some evidence from being considered by a judge or a jury, but an arbitrator may consider that evidence. Thus, an arbitrator's decision may be based on information that a judge or jury would not consider at trial. If certain information from a witness is presented by a document, then there is no opportunity to cross-examine the testimony of that witness. And also, discovery may be more limited with arbitration. In litigation, discovery is business entity who is not a party to the case to provide certain information or document. As a result, many times arbitration is not agreed to until the parties are already in litigation and discovery is completed. So by that time, the opportunity to avoid the cost by using arbitration may be diminished. And also, if arbitration is mandatory or required by a contract, then the parties do not have the flexibility to choose arbitration, only when the both parties agree. And also, mandatory arbitration allows one party to force the another party to use arbitration. In situation where the arbitrator is reliant on one party for repeat business, then the potential for abuse is present and the advantage for impartiality is lost. And also finally, the standard used by an arbitrator are not clear, although generally the arbitrator is required to follow the law. But however, sometimes arbitrators may consider to be apparent fairness of the respective parties' position instead of strictly following the law, which would basically result in a less favorable outcome for the party who is favored by a strict reading of the law.
Well, Vinisa, I guess I am against the arbitration because do you all know what is the conventional litigation? Now allow myself, Sophie and Jessica to explain on litigational as well before decision taken. So, litigation is an ancient process that involves determining issues through a court with a judge or jury, and formal process conducted in public courtroom only. Type of proceeding public in a courtroom, and evidence only allowed based on the rules. No jurisdiction allowed and judge appointed by the court, limited input for the parties. And of course the case can be possible to appeal and must wait for case to be scheduled. It will take a long time. So as usual, fee for the court and advocate is normal, and essential and extensive use of advocate.
Exactly, Ganesh. Now allow me to explain them on the advantages of litigation. For the first one is formal process. One of the advantages of using the litigation process is that all the processes are carried out formally by an official state agency. So the whole process from the initial registration to the final trial is very clear and detailed. That way, the plaintiff can clearly know every process that will be carried out, from registration, payment, mediation up to the final result. Every process that it passed is recorded in official documents. And the second one is the judge's decision does not involve disputing parties. Another advantage of litigation is that the judge's decision does not involve the disputing parties. Instead, it will be based on the information and evidence collected and the testimony of the witnesses. So, the decision of the judge is neutral and based on the existing facts. The third one is the court process is conducted openly. The litigation process in court is carried out openly. That way, anyone can attend to see the trial taking place and to hear the court's decision. The time required in the litigation process can be either short or long. The more complete the data and evidence, the faster the process. And for the last one is binding and inviolable results. The judge's decision has permanent legal force and is binding on all parties to dispute, both the plaintiff and the defendant. One of the crucial things needed in the litigation process is a team of experts and experienced lawyers. Therefore, it is very important for parties who will be involved in the litigation process to immediately get legal assistance from the team that has experience in handling various disputes. At ADCO Law, we have several teams of experienced lawyers who have handled various disputes ranging from civil and criminal cases to industrial relation disputes. We offer highly quality service from representing clients at all levels of the trial to the final resolution of the disputes.
Well, after knowing the advantage of litigation, we should also know about the disadvantage as well. So litigation is not as predictable as it may seem, as many people wrongly believe that they will be able to accurately predict the outcome of business litigation before committing to it. However, this is unfortunately not the case. Subjective judgment can play an influential role in the outcome of litigation. Litigation is impersonal, as in mediation and other forms of legal consulting, you may have the opportunity to use empathic communication and rapport in order to persuade the parties involved. In litigation, this will not be possible. Instead, the person making the judgment will only have to have the key facts, as this is something to consider carefully before deciding to proceed with litigation. Litigation can burn bridges, as it should only be considered going through litigation with another party if you have been accepted that there will be no future business relationship between you and them. In litigation, relationships can be severed, and this could harm future income as well. If it is dealing with a business dispute, there are several possible options. By understanding the law better, and it will be equipped to make the better possible decision for the situation.
Guys, now I feel that arbitration is better than litigation, especially when it comes to business-related issues.
Okay, wait, let me explain a simpler version. So arbitration and litigation are actually both formal methods of settling business dispute. They differ in who hears the dispute, how the process works, and whether the decision can be appealed. Arbitration processes are overseen by an arbitrator, while litigation is under the control of a judge. The decision of a judge can be appealed, while decision of an arbitrator is usually binding on both parties and also has limited appeal rights. So mandatory arbitration clauses are common in many business contracts.
Yeah, I agree with you, Nisa. In business-related issue, litigation is considered to be an illegal aspect.
So, in conclusion, we guess now you three have to agree with us for using arbitration as a form of dispute resolution for business-related issue is better than using the conventional litigation approach in the court. Do you guys agree with this, or you want to continue the debate?
Yeah, we agree.
Yeah, we agree with you now.
Great. Finally, we have come to an end of our debate on using arbitration as a form of dispute resolution for business-related issue is better than using the conventional litigation approach in the court of law. Thank you.
Thank you, Shah.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.